have a microphone. I want to make sure that everyone's access needs are met. Is there anyone in the room that needs me to use the microphone, or should I forgo it?
I think Sophie probably good.
Okay, I
Thank
can
you.
see if I can remember how. Hello? Oh, there it is. Okay. So as Beth said, I work at the Center for Disability Rights, and I'm a systems advocate there, which means I work to create a world, a society that is more accessible for everyone. And specifically, I work on housing, employment, and access to the community, which means I help make housing providers become more accessible, putting policies in place, perhaps make housing that is, in fact, accessible. I help with employment, which is why we're here, in that I help employers understand the rights and responsibilities they have, as well as I help them put in policies to make sure that people who need their accommodations are obtaining their accommodations, and that they are properly conversing and discussing and making that a two-way street. And then I also help with general access in the community. So what that means is I work with businesses to make sure that they are serving their customers, their clientele, as best as they can. I've worked at CDR for approximately 10 months now. Got the job right out of college, so not that far from some of you, and I've been learning ever since. So just to give some background, I am a disabled person. When I was a child, I was in an accident and had my leg amputated, and that began my process to here. So specifically, we're going to talk about accommodations at work and how to request accommodations, how to make sure that you're not getting discriminated at work. So the Americans with Disabilities Act is the primary law at play. There are a couple other laws at play, but that's going to be the primary focus for anyone who's asking for accommodations. Do we have a general knowledge of the ADA? Do people at least know of the ADA? Maybe? Have people requested accommodations before for their job? Okay. So the Americans with Disabilities Act has several titles dealing with a couple different sects, but specifically we're talking about Title I here, which prohibits employment discrimination against qualified persons with disabilities and requires employers provide reasonable accommodations to employees and applicants with disabilities. And I want to really point out a few things here. Qualified persons, meaning you are able and have the skills to complete the job with or without accommodations. So if you can do it without accommodations, great. If you need some accommodations, but that qualifies you, that's also great. But we also want to make sure that people who just decide that they want to be a hairdresser one day and get no training can't just go in and cut someone's hair. That's kind of the difference. You have to be qualified for the position. You can't just up and decide to apply and then get upset when they say no. It's not because of your disability necessarily, it might be because you genuinely aren't qualified. And this is enforced by the Equal Employment Opportunity Commission. However, there are other entities that will also step up and kind of make sure that there isn't discrimination taking place. I also want to point out that it does not just apply to employees, it also applies in the application process. So if you need accommodations to apply, they can't refuse that. I will say though that it is harder to show discrimination in the application process as compared to once you're actually an employee. So unfortunately, I would say take note of that if and when you feel like you're being discriminated against. So kind of going deeper into this definition, the threshold of protections in the ADA is you must be disabled and you must be able to complete the essential functions of the job with or without reasonable accommodation, which I kind of got into a little bit. So the first one, must be disabled. A lot of people in our world, and I guess this is a good part to say this, don't necessarily want to identify themselves as disabled. And I get that. There's a stigma around that word. You don't necessarily want to admit that there might be something wrong with you. But we at the Center for Disability Rights believe in the idea that it's not that there's something wrong with you, it's that the society, the community you live in, is not accessible and conducive to you. The society has been built that disables you. I'm not sure if that necessarily makes sense, but we really want to make it clear that it's not a bad thing to be disabled, and it's important. When you look at these kinds of laws, they all say disabled. They don't say, oh, special needs, or any kind of other wording. So disabled has a physical or mental impairment that substantially limits one or more major life activities. So then you get into what is a major life activity? Breathing, walking, eating, going forward. And the thing that's really clear there is that the quote-unquote impairment can exist whether you have accommodations or not. So I may look like a perfectly able person, but the minute you take away my prosthetic leg, I can't walk, I can't stand. So in that sense then, I have an impairment that limits one or more major life activity. So when you're looking at that definition, you're taking out any kind of accommodation that you might be able to have. Has a record of such a physical or mental impairment. So if you have a record or your doctor has indicated that you have had a disability in the past, the law can still pertain to you. And sometimes this goes back to whether or not you choose to identify as disabled, if you are regarded as having such a physical or mental impairment. So some people might not have the intellectual capacity to understand that they are disabled. But that doesn't negate their disability, and that doesn't mean that the doctor can't speak on their behalf or like write a letter, and that the employer is out of that. Like I said, a major life activity is walking, standing, hearing, seeing, eating, kneeling, and it goes into a lot of depth with that. So if you're not sure if something's a major life activity, you can definitely look it up. Okay, so the other threshold of protections in the ADA about employers is that they must be able to complete the essential functions of the job with or without reasonable accommodation, which I kind of went into with the qualification. So it's the fundamental duties that the person holding the job must be able to complete. So it might be why the job exists. It might be that even though it's a pretty general thing that isn't necessarily explicitly stated out, only a few employees can perform that job. So the example we generally give is if a blind person decides they want to be a pilot, that's not necessarily a job that the flight attendant can do, that the guy at the counter can do. That's a pretty specific job with specialized training. It can't really escape that. So we also consider, if you aren't really sure if it's an essential function, but you know of the job, if you can gauge based on current employees how much time they spend on it, what would happen if you didn't complete that? What could that lead to? Firing or something like that. Whether other employees could complete it. So if it's a job, doing filing, and you're in a wheelchair and can't reach the top of the cabinets, but there are other employees who also have to do the filing. If you can find a way that the other employees will do the top of the cabinet and you'll do the bottom of the cabinet, that would be an acceptable change because other employees can complete the task. Okay, so now that we've kind of gotten through the legal jargon of it all, I want to get into accommodations themselves. And if you guys have any questions, like, feel free to stop me. I don't want you to be sitting there holding on to the question and to miss everything else. So reasonable accommodations and disclosing your disability. I find that a lot of people in these kinds of presentations come to this because they don't know when to disclose their disability or how to disclose their disability. They don't know if they've already disclosed their disability to their employer, and they also don't necessarily know the importance of disclosing their ability. They don't know if it's necessary. So, it's very basic. Reasonable accommodation is any change in the work environment or in the way a job is performed that enables a person with a disability to enjoy equal employment opportunities. So that removes barriers, whether they be physical or procedural. And there's a lot of things. So when they wrote this law, they were very specific about the wording. So one of the most important things I feel in this is equal employment opportunities. So it might be a physical barrier. It might be that there are steps to get up to the stage, so they build a ramp. But it might be a process, a procedure, or a policy. So perhaps it says that you have to be to work at this time every day. You get a 15-minute break, and that's it. If there is someone who maybe needs to take more breaks, perhaps they have a chronic illness or something like that, but they're willing to come early, that might be an accommodation. And the other really important thing is it's equal employment opportunity, which means that it's not a static thing. If you want to go to a training, if you want to progress in your field, but you need specific opportunities, they also have to take that into account. So if they're saying, well, everyone who works this job has to go to a training, and the training is up a set of stairs, they can't say, well, you can't move to be a supervisor because you can't do this training because you can't get up the stairs. They have to find an alternative. That might be an online version, or that might be having someone video conference you in. It's not just everyday, day-to-day job. It's also opportunities. And it's also equal employment beyond your job. So your break room. Your break room has to be accessible to you. It's not just the duties you're fulfilling. It's the environment that you're fulfilling it in. So like I said, there are 3 types. Changes to a job application process. So that's before you get the job, you can have accommodations put in. Changes to the work environment or to the way a job is usually done. And changes that enable an employee with a disability to enjoy equal benefits and privilege of employment. So access to training. And that's the one that we tend to get stuck on, is that people don't necessarily think beyond, this is their job, this accommodation works for them, boom, we're done. So let's kind of go into requesting accommodations. The law was written in the 90s, and things have progressed since then, but the law is still the way it is. So it's vocal or written, there's no language you have to use, and it lets the employer know that you need an accommodation due to a disability-related purpose. So what that means, basically, is that there's no cut way to do it. There are a lot of ways that might work better for you and the employer, but there's no clear thing except you say, A, I have a disability, B, I need this to do my job because of my disability. While we encourage you maybe to mention the ADA or reasonable accommodations, you don't need to do that. What you need to do is make it clear that you have a disability and that you need accommodations. Beyond that, you don't have to do anything in requesting the accommodation, because now it becomes a conversation. So I do want to say, because you're not just here to know the basics of the law, you're also here to kind of hear how we as experts encourage people to deal with this. While it doesn't need to be in writing, an employer can ask to have a memo or letter written for confirmation of request. So they can say, hey, we need this written down, we need a doctor's note, and what that does for them is kind of enforce that this is true. But what it does for you actually is that it allows you to kind of timestamp it. Because if you go up to your supervisor and say, hey, can I have this? I have a disability. And they don't remember it, you can hold them accountable, but it's going to be a lot harder if it's his voice against your voice. It's his side of the argument against your side of the argument. And the thing that kind of makes you notice that this is a kind of an older law is that if the disability or the accommodation is not obvious to the employer, they can ask for documentation or medical information about the disability. With that said, they can just ask for medical documentation about what the disability is. They can't ask for your records or your history. They can't ask what your maiden name is. They can't go into detail about this. When did you get the flu shot? They can ask, can I have a doctor's opinion on this? But if it's obvious, then they can't ask you to go through those extra hoops. So if I'm in a wheelchair and need the ramp to get up onto the stage, that's a pretty clear, here's my disability, here's my accommodation. If, however, I have poor mobility and I can't get up the steps, but I can get up a ramp, if that's not necessarily clear, I might have to show documentation saying she's arthritic, she can't use stairs. Does that make sense? Okay. Okay, so now we're going to get into the sticky wins and what ifs. And I kind of, when I've presented this previously, we've had discussions of the merits of different things and how to do that, and we can get into that as well. The merits and the different ways to apply. The different ways you want to say it, the different times when you want to say it, and why you might say it that way. And oftentimes you kind of come to a thing where if you say it at a certain point, you might receive backlash, and people are always like, well, maybe I shouldn't do it then. But what I always kind of tell people is if you're going to say something before you apply, if they're not going to respond positively, are you sure you want to work there? And unfortunately, that's not necessarily the best answer I can give you, but that's kind of where we look at it. So there are 3 different times. When you apply, directly after you get the offer and you accept the job, or later on down the road when you realize you need an accommodation. If you disclose your disability during the application and interview period, there are a few things that are completely unacceptable and allowed. There are a few things that are completely off limits. They may ask if you can complete the task or the function of the job, and then ask you for a description. So what that might look like is if someone is in a wheelchair and they're applying to be a cashier at a grocery store. One of my coworkers did previously. And she went in and they said, well, how are you going to be able to use the cash register when it's above your eye level? And she kind of explained, like, well, you lower the counters and you lower the cash register, and then you can use it. That's how I can use it. And then the other thing that she put in, which is what we always encourage, is then explaining how that's actually helpful to customers, to other employees, kind of highlighting how this accommodation can actually make things better for the employer. Well, if you lower the counter, then other people in wheelchairs who are customers can now reach. Or people who need to sit, who are injured, can now use that register as well when I'm not there. And they may ask about qualifications and skills. They cannot ask medical questions. They can't ask for documentation of your disability necessarily. And they can't ask if you have a disability. If you don't disclose beforehand, you can't come in and they see, oh my gosh, she's in a wheelchair. Do you think she's disabled or do you think she's just using it? And they can't ask the nature of the disability. Oh, did you get it? Were you born with it? Oh, poor thing. They can't ask any of those questions. They can't ask personal and private questions during an interview. It's a professional setting still. Yes.
Okay, so if someone is asking personal information before you've already volunteered the information about your disability, you know, because you also want to include education during that process so that they're prepared for the next time that they interview a disabled person. So meaning that they can't ask you, so they can't ask you personal information without you volunteering that first. Like some people are actually disabled and don't mind being asked personal questions, but you're saying that it's only okay if the information is volunteered, right?
So yeah, they can only ask you questions about your disability if it's volunteered, but they also can't go into personal depth. If you feel comfortable sharing that information, go right ahead. If the person interviewing says, oh, I see you went to a deaf school, what does that mean? They can't ask you questions like that. But if you want to volunteer information, that is completely up to you. It is your own information after all. Good? Okay. So what I always encourage is that when it comes up, if you've shared your disability ahead of time, maybe because you need accommodations, you want to see if the building's accessible to you, you want to make sure when the questions come up that you return to why you're a positive candidate. Maybe what your disability brings to the atmosphere, what it might help to do. And because they're going to maybe ask you about how you're going to be able to complete a task, you might want to put some time in ahead of time during your interview and kind of think about, well, if they ask me this question, this is how I can answer. If they ask me how I can complete this task, maybe it's an opportunity for me to educate, like we were just talking about that question. It might be a good opportunity to help them move forward. Because at the end of the day, you're there, and if you've applied to a job that you feel qualified for, you're there for a reason. You don't have any reason to make yourself grovel or anything like that. You have a right to have a job like that. And you're qualified. And they should know that. And they should be able to see that part. Okay, so it's after the interview, and they are going to give you a job offer, and they know about your disability. They can't require you to take a medical exam or go to extra doctor's appointments unless it is a situation where everyone has to go through that. Do you have a question?
Yeah, so before the presentation, so there are a lot of deaf and hard of hearing students who are looking for jobs. How do you request interpreters for that? How do you successfully tell employers, I'm deaf and I would need an interpreter for the interview? When do you suggest letting the companies know that you would need let them know that you need an interpreter for the interview? And what's your advice for students as far as when they're applying for jobs, requesting interpreters for their interviews?
Okay, so first of all, you're going to want to do it earlier than later. Don't delay on that because if they don't have experience with deaf employees, they're probably not going to have a policy in place on how to handle that. And they probably won't even know where to start. If that's the case, we always suggest when you say, I need an interpreter, say, this is where you might be able to find a qualified interpreter. This is an interpreter that I know is helpful, is good. But you don't want to delay it because you want to give them as much time as possible. But also, it's not your responsibility to A, find the interpreter for them and pay for the interpreter. That is their responsibility. If they don't do that, then that's when you can maybe complain and say, what the heck? But you shouldn't show up to the interview and say, here I am. Oh, you didn't get an interpreter? Did you have follow-up? Did you want clarification? Maybe, I don't know.
your explanation was perfect. Thank you. Good work. But now, the other question that I have is some students are afraid to ask. If they already have an interview scheduled, then they're a little bit nervous. They say, should I email and ask for an interpreter? And if the interviewer says, if there's no response, or if they say, oh, we might need to reschedule then, or maybe they cancel the interview on them. So if someone experiences that their interview is canceled after requesting an interpreter, is that considered discrimination?
So I would say, first of all, email them, ask them for an interpreter. If they don't respond right away, maybe try again and say, maybe my email got lost, I'm not sure, the interview's coming up, I'd like to double check on this. If they agree to reschedule it, that might genuinely be them saying, either we need time to find an interpreter, we need to figure out how to get an interpreter, but if they're willing to say, we'll reschedule it, or ask you about dates, then I would say that that's probably a good indication that they're not bailing on you. If they say they're canceling, you might want to, and honestly it's a situational thing, it depends on how the interactions have gone, you might want to say, does this mean that you are not going to be pursuing this anymore? Are you canceling? Like, you might ask for clarification, but in some cases that might be outright discrimination, and that's when you might contact a disability rights lawyer. You might contact us at CDR or another disability advocate who can help you navigate that process. Depending on how you want to continue, you could put in a complaint with a Department of Human Rights or EEOC. It's up to you on how you want to pursue that. And I will caveat that if you do complain, it does take time. It's not going to turn it around. The only thing that might turn it around is when they get that complaint and they go, oh no, we are screwed, we should probably fix this before it goes any further, and they like panic. And that sometimes works. That's also why I encourage you to reach out to an advocate or a lawyer, because sometimes just getting a phone call saying, hi, this is the Center for Disability Rights, and we heard that you canceled an interview with an applicant after you found out they were deaf. Can you explain to me why you chose to do that? Sometimes just hearing someone else calling and questioning their actions might scare them enough. I will say also that if they say we need to cancel, we need to reschedule, we need to figure this out, asking, do you have a policy on this? What is your policy on this? Which, A, kind of makes them realize, oh no, maybe we should have a policy on that. And B, sets it up so that if you end up interviewing, if you end up getting the job, if you're there, they've already started thinking about how are we going to handle further interactions with them. Is that helpful?
Yes, thank you.
Trying to see if there's anything left on here. Oh, okay, so I will say, if there's a concern that the employee cannot complete the job safely or successfully, and people's health or safety are at risk, that might be a legitimate concern. So when the ADA was written, people with AIDS and HIV were also part of that process. And so what that means is if you have AIDS or a transmittable disease, and there's a chance that your body fluids might be able to be swapped with someone else's through your position and putting other people at risk, that might be a reason they can't accept you. But that doesn't necessarily mean that they can turn you down automatically. They have to show, based on data, that they, like objectionable data, that you actually are putting someone at risk. So maybe that goes back to the deaf pilot, not the deaf pilot, the blind pilot. He's probably going to be putting someone's life at risk if he tries to fly. So the other thing we want to make sure is clear is they cannot rescind an offer if they are afraid of future disability or future needs because of your disability or out of prejudice to a disability. So they can't say, if you bring up in an interview, my mother has dementia, and that's why I have experience, and that's why I want to go into this field. They can't say, well, if your mother has dementia, maybe that's a genetic disorder that's going to get passed down to you, and so maybe we should hire you. They can't say, well, we're afraid that you're going to need more needs in 3 years. They can't use that as a reason to take an offer back. So a lot of people might want to not disclose, but we think it's really important to disclose because they're not required to give you accommodations unless you disclose. And if you don't disclose, if you start having issues and you figure out later that it's because of your disability, if you don't disclose until they're about to fire you, it's not going to look good on you, A, and B, it's going to be a lot harder to come back from it. So if you've gotten a lot of warnings because your paperwork is scattered, and you know that the reason that your paperwork is scattered is because you have ADD and it's really hard to complete it on time, so it's not to the best of your capabilities, they're not going to think to give you an accommodation. They're not going to think, oh, maybe this person needs more time to finish this. Maybe this person needs a proofreader. They're not going to offer that to you until you ask for it. But I will say that if you don't disclose, you're not a bad person. If it's not important to the job and if it's not going to impact any part of it, you don't have to disclose. You don't have to disclose right away. You don't have to disclose before the interview. If it's not going to affect anything, then you don't have to disclose. Just make sure that you're doing it in a way that you are going to get your needs met before it becomes an issue.
Question?
Yeah.
Sorry. The class before, I have two questions, I guess, before I head out. The middle part here, I guess. So you're saying on the, like, say there's a table and,
so if the counter can be lowered for people in a wheelchair, but what if the company can't afford that? Should you just kind of let it go or see if there's another way around that? And for requesting interpreters, if companies say, oh, we can't afford that or we can't afford special equipment, if they list financial reasons or maybe if it's a rehab facility or something like that and they can't afford something like that, what do you suggest the response is if they cite financial reasons?
Yeah, so in the law, and we'll get into that, but unfortunately you won't be here, there is stipulation that it can't cause undue burden on the business. But what we find actually is that they use that as an excuse without necessarily grounds in it. So a lot of businesses don't want to provide something unless they have to. And so if they think this might cost me something, then what we say is, well, how much are you losing if you don't have that employee? If that's a really qualified employee, then you might just be losing that. And there have also been studies done, which I was going to get into later, but I can get into now, that say accommodations on average, when you interview employers, they found that the median cost was about $500, and they were willing to pay up to a median of $300 for a non-disabled individual. So
they're willing to pay how much?
$300. So if they've said, well, we're willing to say $300 set aside for this employee, this new employee. But the average is $500. We think it's often seen as, oh, well, this is an undue burden. They look up ADA and they say, oh, right here it says I can get out of it. I say undue burden. But oftentimes, that's just a hollow thing, and you might come back to them and say, but is it really? Is it worth this? And oftentimes that might be where you kind of look into it yourself, or you ask an advocate to say, like, how do I do this? So I have a case that they were told, well, that's an undue burden for us on our department. And he said, really, why? And they were like, and stammering, and they also were like, oh, this is not a real excuse. We're just saying that because we thought we could get away with it. Now I'm trying to remember what the question was. So I guess what I would say is it's really important for the employer to realize that while it might seem like a financial burden, in the long run, it's probably going to save them money. And that's where you kind of have to get to them. Well, these are the skills I have. These are the qualifications I have. Are you willing to look for someone else when I'm perfectly capable of completing this task? And the second question was about counters.
Yeah, the second question, really for like here, we have international students or the internships or whatever they go, and they have to find, like, they use services to go to study abroad things and stuff, but, or like some services they can't use, or they have an ID card and everything.
Yeah, so international students, some can use CDR services and can use American associations, but some of them aren't U.S. citizens. So there are some policies that say that they can use their services and some that aren't available for international students. So what services are accessible for international students because a lot of these services are only for U.S. citizens.
So can I clarify this? So do you mean specifically CDR services, or do you mean services at NTID?
Just in general.
Oh, in general. Okay. So what we find is that,
Like if something happened and I needed to have different accommodations or whatever, would I use your services to have a lawyer or something to discuss, to solve the problem kind of thing? Like maybe if they can't get a lawyer, or maybe like, are they all the same for all students and everyone? Like, yeah.
I'm going to try and answer this question, and if I answer it wrong, just correct me. So if the employer employs people in the United States, then the law is applicable to them, and so they themselves need to follow through on the laws and the policies. So if their employee is from somewhere else, if they're from Canada, if they're from France, if they are employees in the United States, these laws still apply to them, and the services still apply. If you're asking specifically about like CDR or disability rights in New York or other lawyers, there are generally lawyers across the United States, and they can figure out usually how to find you funds or help you figure out someone who can help you if you're in need of income or something like that.
Okay, thank you so much. Thank you for the clarification.
Okay. Okay, so when it comes to disclosing your disability specifically, we find that a lot of times people don't know who to disclose to. And generally, if you disclose to your supervisor, that's usually the route that most people take. If you're finding that you're not getting your accommodations or they're not responding positively, it is completely worth your while to go to the Human Resources Department. If there's an ADA compliancy officer at the company, finding someone who can help you, because a lot of times supervisors don't really know what to do, and if they don't know what to do, they might just drop it. We have a lot of consumers come in and say, I told my supervisor this 3 times and they never did anything, and I don't know what to do. While it doesn't necessarily change the fact that your access was neglected, it helps if you can say, if you went to an HR department, or if you looked in the policy to see who handles it. Because if it's not the person you're talking to, you might not be getting what you need. It's also advisable to provide basic information about your condition or your impairment or your disability, the limitations that comes, and the accommodation needs. We suggest that because it starts the conversation off right. If you go in and say, I'm deaf, I need VRS, and my limitation, the reason I need that is because I can't use a normal phone. If you do that outright, then that leaves less gaps for them to say, well, you told me you had a disability, but you didn't tell me what you needed, so I just got you this other thing. I'm sure it'll work fine. I've read reviews on Amazon that it works. Your employer is allowed to ask questions or request medical information to establish that you have an ADA disability. With regards to that, it goes back to what I said previously, which is if it is obvious what your disability is or what your need is, then they cannot continue to ask you questions or ask you to bring in medical records. So if someone in a wheelchair says, I need a different desk because my chair doesn't fit under the desk, that's a pretty obvious disability, a pretty obvious accommodation. But if you go to your employer and say, I need a new chair for my desk for my disability, they might be liable to ask questions, in which you might say, well, I have a disability where if I sit in a desk with a bad back support, then it triggers my spine and then I have seizures. That might be how you explain it. Alternatively, you can't go in and say, I don't like this chair and I'm disabled, so give me a new chair. Because we see people who go in sometimes and they know they're disabled, and so they use that to change the environment they're in without really thinking about whether or not they actually need that. And then they're like, well, of course I did that. I'm disabled. No, not really. That's not really how this works. Okay, so kind of wrapping up the whole WIN thing. We suggest if you're applying and you feel your experience says something about who you are as a person, who you are as an applicant, or qualifies you for the job, that might be a reason to disclose when you apply. Or if you're going to need accommodations for, say, the interview, which is what we were discussing earlier. So, for example, I disclosed my disability when I applied to my job because it was at the Center for Disability Rights, and it kind of helped, solidify my reasoning for applying. We suggest if you know you're going to need accommodations after you're offered the job and have accepted it, to disclose your disability. You don't have to do that, but we suggest it because what that does is it gives them time to get you the accommodations, and if there's a period of time before you actually start the job, maybe they'll have them in place before you even get there, and it sets you off on the right foot. And later on might be if you don't think your disability matters to your work or how you complete the job, but then you start noticing that you can't quite do it to the degree you want to do it, and maybe this accommodation would help you. You might want to request an accommodation, even if you didn't indicate before that you are disabled that you need an accommodation.
That goes. Hello.
The battery says it's dead on the other one. Okay, you can request accommodation even if you never indicated a need previously. So even if they don't know you're disabled, maybe they don't know you have ADD, or maybe they don't know that you have arthritis, but then you realize you need it, you need an accommodation, it's worth bringing up. If that's the case, we really urge you do it once you notice the need. Don't wait until you have had issues where they're maybe discussing firing you or they've given you warnings. Bring it up as soon as you can so that A, you can get a better workplace for yourself, but B, it doesn't cause animosity. Because again, if they don't know you have a disability, they can't give you accommodations. Well, they can, but they probably won't. Short answer to the last 20 minutes is, if it feels right to disclose your disability, or it feels necessary, disclose your disability. Okay, so this gets to the questions we were discussing. In the ADA, it says that if it is causes undue hardship or undue financial burden for the employers to create reasonable accommodations, they can choose not to hire you or to provide the accommodations. However, we think it is worthwhile when they come up with that to respond and say either ask what the hardship is, unless they maybe have pointed out blank, or find a way to discuss an alternative. Exceptions to a reasonable accommodation are also changed to the nature of the job. So that might be, going back to that blind pilot, what exactly is the job if you've just changed it because he's blind and he can't actually fly the plane? If it requires the employer to lower the quality or production standards. So, blind pilot's not necessarily going to make a really great quality flight. If the disability poses a direct threat to health or safety, which we kind of talked about before, the very important part of that is that they have to have evidence. They have to have true, real, objective, and factual evidence in that conversation, and it can't just be, well, in the previous jobs, we've had previous deaf people work here. It's created this kind of issue. Well, that deaf person was you. So they need to maybe give you an opportunity. And the last thing is, you can't ask for a personal item to be your accommodation. So you can't ask your employer to buy you new glasses or maybe buy you a wheelchair if you also use that outside of work. So when it comes to finding an accommodation that fits your need, we generally encourage you to start a discussion process. It is not a one and done thing. You will find that you maybe need different things as your job progresses, as technology progresses, as you move up the ranks. So finding accommodations isn't I need an accommodation, I'm disabled, this is what I need. It's sometimes, I'm disabled, here are some things that have worked for me, what can you do? And maybe they'll come back and say, well, this thing's kind of more expensive, but maybe down the line we can get it, but can we do this for now? And there may be more questions involved because a lot of employers don't necessarily know about the best way to provide a reasonable accommodation for your specific disability. And they might not have a policy. They probably don't have a policy, actually. So it's going to take a back and forth, but at the end of the day, you want an informed decision made based on your disability, based on your skills, your qualities, your personal experience, which is going to make it more informed than emailing saying this is what I need because of this. I want it now. With that said, they must provide an accommodation unless it's an undue burden. They cannot avoid it or just look past it. And they must have options of providing or paying for an accommodation. You, the employee, can offer to say, if this costs too much, would you be willing to go half with me? That's an option you can do if it's creating a serious undue financial burden. If the question of undue hardship or undue burden is coming up, if there's an acceptable alternative, that might also be an option. So, for example, if someone is applying to a job and they're blind, and there's a written test as part of the interview process, if they go in and say, I'm applying for your job, I'm qualified, except I can't take the written test because I can't see the questions, can you have someone sit with me and read the questions to me while I take the test? Perhaps it's a small business, they only have 1 or 2 people in their HR department, they can't really afford to have someone sit there and go through the test with them. Oh, we'll give it to them in Braille. If the blind man comes back and says, I actually can't read Braille, I'm recently blind, I've never learned to read Braille, it's not pertinent with today's technology, something like that. If they can then together come to the conclusion, well, if someone goes ahead and tapes it ahead of time, or we find software to read it to you, is that an acceptable format? If that's an acceptable alternative, they can provide that. And they can decide whether or not that's the way they want to provide it. You don't necessarily get to decide the exact accommodation they're going to give you. If there are several options, they can choose which option they feel most comfortable giving you. Okay, so you went to work, you got your accommodations, or maybe you didn't get your accommodations, but you've disclosed your disability and you've asked for them. If they refuse to provide accommodations or provide accommodations that do not meet your needs, perhaps whether you guys came to the conclusion that you would try it or not, if that doesn't work, you have to go back to your supervisor, your human resource department, and ask and say, this doesn't really work for me. I thought it would, we both thought it would, we kind of talked about this, doesn't work for me. If that doesn't work, maybe you go to an advocate or a lawyer who might go and call them and say, I heard this doesn't work for them, I know that you kind of talked about this, but now you're not responding and not updating. Or, if it's really bad, which sometimes happens, that's when you can file a complaint with the Equal Employment Opportunity Commission, or in New York specifically, it's the Division of Human Rights, but it changes from state to state to state. They all have divisions of human rights, but not necessarily by that name. If the request has been made, and they've waited a long time, and there doesn't appear to be action taken, then you might follow up with them, or you might go to an advocate, or you might file a complaint. That might be the interview that we're talking about, where they said, well, we'll have to reschedule. And then a month goes by, and they haven't rescheduled. They haven't returned your emails. Okay, but then you never got your accommodation, you never got to go through the application process, and now you don't know if you have an opportunity with them, and should you hold out or not. That's not really fair to you, and that's when you kind of go and start maybe reaching out to someone else and saying, how do I do this? What do I do? Sometimes what happens is when you reach out to your supervisor and say, I want this accommodation, I need it for this and this and this. And then a week or two goes by, nothing. You haven't heard anything. Should you go to HR? You go to HR. Oh, you needed an accommodation? We haven't heard about it yet. That's not acceptable. You can't just be put on hold on the back of the burner. That's not acceptable, and we see that as discrimination. And oftentimes that's how it happens. People won't necessarily say, sorry, no. They'll just be like, if we hold out, maybe the person will just stop and we don't need to pay for this. Alternatively, if you've disclosed your disability, whether or not you've gotten accommodation, if it has changed the environment you're working in, if you're feeling harassed or discriminated against, if it's creating a hostile environment for you, you don't have to stay in that. You don't have to say, well, they gave me the accommodation, so this is fine. You can go back and say, they're picking on me because of my disability, they're bullying me, and they're making this an environment where I can't get my work done. That's completely acceptable. That might be when you get an advocate involved. And oftentimes, unfortunately, that's when people kind of use that as a way to push people out. They say, well, if we just ostracize them, maybe they'll leave. And so that's sometimes when we have to file a complaint. I will say, in regards to filing a complaint in any of these cases, if you're worried about that, if you want advice, should I do it, should I wait, what should I do? That's another reason why you should reach out to an advocate or a lawyer. Because they can tell you, yeah, this is completely grounds for this. Look at that email you sent, like that is a very valid email. So these are kind of other things that are good to know. The ADA protects people from discrimination based on their relationship with a person with a disability. So that's kind of going back to, well, if this is an issue that happens to your brother, we're not going to hire you. They can't do that. They cannot, however, be required to give you accommodations because of that disabled family member or friend or something like that. If you are having issues, the Family and Medical Leave Act can oftentimes be used if you're worried about your disabled family member. That's kind of a different presentation though, and we can totally have that too if you'd like. Lastly, I think it's really important to briefly touch on Section 503 of the Rehabilitation Act. This specifically covers federal employees. So, employees and employers. So, the ADA is specifically targeted towards private businesses who provide public accommodations. Generally, you can't enforce it as well if the business is small, if it's less than 15 people. but that's the ADA. If you're looking to get a job in the government, you're going to want to talk about Section 503 when you ask for accommodations. And the important thing to note here is that Section 503 actually imposes affirmative requirements. So that means that if you're disabled, they might want to increase their population of disabled employees. So if you're looking at getting a job within the government, it's worthwhile sometimes to mention that you're disabled, because they're under different regulations that kind of indicate that you are someone worth including in the employment atmosphere. The rate of employees with disabilities or some other minority factor, because it's so low, Section 503 actually enforces the idea that we should be putting qualified people into these jobs. Do we have any questions? Yes?
I'm sorry, but could you go back several slides where you talked about the health and safety?
Yes.
So 1, 2, 3, number 4.
Health or safety?
Yeah.
Yes. Do you want me to expand on that?
Yes, could you?
Yeah, so one of the factors that might come to play is if a reason that you're disabled causes a risk to other people, then that might be a reason why they won't give you an accommodation and won't hire you or let you keep your job. So if they find out that you have epilepsy and you get seizures from flashing lights and you want to get a job as a truck driver, they can say, well, that might put a risk to other people's safety because you might have a seizure on the road. Does that make sense? With that said, though, it does go back to they can't just decide that because they've seen this in other cases, this applies to you. It has to be based on like your doctor's recommendations, how it interacts with you. So one of the cases might be if, say, that person who has epilepsy decides they actually want to work in a kitchen and they're put on as a prep worker and they do a lot of cutting and stuff like that, cutting carrots and various things. And the employer says, you have epilepsy? Doesn't that mean you have seizures? What if you are cutting something with a big, heavy, sharp knife and you have a seizure during it? If you have medical records or medical history saying you haven't had a seizure in 10 years, then that negates their fear of health or safety. Because that's not actually truly a real reason. They're just maybe coming up with something because they have an idea of what a disability is. Are there other questions? If not, that's okay. Yeah.
So I'm a vocational counselor, and so when I'm assisting individuals fill out job applications, a lot of people tend to be concerned of disclosing or stating whether they are disabled or not. And so I have never seen what employers receive on their side when when an application is completed. So do you know on that part of an application, does it disclose to the employer themselves that they state that they claim that they're disabled or not? Because I don't know.
If I remember correctly, it depends on the employer. Sometimes it's done for like basic statistics,
Right.
but sometimes it's done because they want to know, because maybe like within the government they want to know so that they can encourage qualified candidates. I can check up on that one for you though, because that I know I've read it, but I can't remember. We are at 2 o'clock, but if people are interested, I do have a couple like example job job descriptions that we can look through, and I can kind of explain what you're looking at, what might become a qualifier or disqualifier. That's up to you. If not, you can eat pizza and go back to whatever you were doing at 2 o'clock on a Friday. Okay, thank you for coming. If you have any questions, concerns, feel free to share them. Come up to me. I actually, I forgot that I had these until after that woman left, but I have the top 10 things to know about employers and the ADA. So if you didn't take good notes or you want the basic information, it's just generally like the quick and dirty. And I also have cards in case anyone wants a card. Thanks, guys.